Major news out of the United States Supreme Court. In the case of Gray versus Jennings dealing with preliminary injunction standards in the context of Second Amendment cases, the United States Supreme Court has issued a major order telling the state of Delaware that they must respond to the pending petition for cert, i.e. the petition that asked the United States Supreme Court to hear the case on the merits, the case of Gray versus Jennings. This has real significance not only for that case, but maybe even for the AR-15 ban case of Snope. Let's talk about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed: What the 10/7 Attacks on Israel Teaches We Americans About the Right to Bear Arms. Check it out on Amazon if you have not done so already. All right, folks, so the United States Supreme Court has issued an order in the pending Second Amendment case of Gray versus Jennings. Now, the Gray versus Jennings case we have covered on this channel before. And in Gray versus Jennings, it was a case arising out of the United States Court of Appeals for the Third Circuit, which is the circuit that covers Delaware, New Jersey, and Pennsylvania. Now, this Gray versus Jennings case basically involves the four elements of when a party, a Second Amendment plaintiff, if you will, is entitled to receive a preliminary injunction enjoining, which means stopping or thwarting or preventing the enforcement of a modern-day gun control law. Now, Gray versus Jennings provides the United States Supreme Court with an opportunity to clarify and fix up a circuit split between those courts, such as the Ninth Circuit, that says that if a Second Amendment plaintiff can establish they are likely to prevail on the merits of the Second Amendment claim, meaning that the modern-day gun control law being challenged likely violates the Second Amendment, then the other elements that usually have to be satisfied in the context of receiving a preliminary injunction in your favor are automatically satisfied. That's what the Ninth Circuit says. If you can show that you are likely to prevail that a Second Amendment challenge by demonstrating that a modern-day gun control law violates the Second Amendment, then you only need to show that. And the other elements of a preliminary injunction, which are balance of the equities, the interest of the government, the public interest, and things like this, are all, including irreparable harm, for example, are all satisfied. Now, the U.S. Court of Appeals for the Third Circuit actually says that a Second Amendment plaintiff, even if they can show that they are likely to prevail on a Second Amendment claim, that's not enough. That the Second Amendment plaintiff must go on and put on evidence before they can get a preliminary injunction in their favor enjoining the modern-day gun control law. They must also put on evidence and demonstrate that the balance of the equities are in favor of the Second Amendment, that their public interest is being advanced by virtue of the injunction in favor of the Second Amendment, and that indeed there is irreparable harm to the plaintiffs, meaning a harm to the plaintiffs that cannot be satisfied by the payment of monetary damages. The Third Circuit has said that all that stuff has to be satisfied, not just that you're likely to prevail. So there's a circuit split about the standards of a preliminary injunction between the Ninth Circuit Court of Appeals on the one hand, out of California, Hawaii, and Washington and the like, versus the Third Circuit out of Pennsylvania, New Jersey, and Delaware. Now, with that context in mind, the United States Supreme Court has just requested a response to the petition for cert, and that this must be filed on or before November 27th. Now, this is particularly important for many reasons. Why is that? First of all, it shows that the U.S. Supreme Court is interested enough in the Gray versus Jennings case, touches on the Second Amendment and preliminary injunction standards, to the point where they want to hear from both sides. They've already heard from the Second Amendment petitioner side saying this case should be heard and resolved in favor of the Second Amendment, in favor of the Second Amendment plaintiffs. They want to hear what Delaware has to say because this case involved a legal challenge to Delaware gun control laws. So now they've told Delaware, you better submit an opposition or tell us what your position is on this by November 27th. Now, why is this particularly important, not just to Gray versus Jennings, but also maybe to the Snope AR-15 ban case out of Maryland in front of the U.S. Supreme Court potentially? And that's because of this. You got to listen to the dates carefully. We're in the 2024-2025 Supreme Court term. the last case, barring some crazy emergency like an election fight, that the U.S. Supreme Court is likely to be granted cert to will likely be sometime in mid-January. After that, the odds of a case being granted cert for the 2024-2025 term, the one we're in now, really drops to almost zero, okay? Absent some extraordinary situation, like this year's case involving Donald Trump and the 14th Amendment being kicked off the ballot would be an example of some emergency kind of case that they would just take because they have to, and they have to resolve it with speed. But that's not what we're talking about here in the Second Amendment cases, as far as best I can tell. So by virtue of giving Delaware until November 27th, that means that Delaware will submit its brief on November 27th. It will likely be distributed to the court for review by the clerks and the judges, the justices, somewhere in mid-December, maybe around December 11th, December 12th, something like that. Okay? And the first consideration, this is key, the first conference that the justices will get together on behind closed doors to vote whether or not to hear the case, the first conference will be on or around January 10th, 2025. Now, given that Chief Justice John Roberts has a policy that if they're going to grant cert to a case, even if they agree to it internally, the case is always relisted at least once to give the law clerks for the justices and the justices an opportunity to look very carefully to make sure that that case that they're considering granting cert on, which means if you grant cert, they're going to hear the case on the merits and decide it. They want to make sure that before they officially, formally do that in a public way, they want to make sure that there's no procedural problem with the case, such as the plaintiff is dead, the case is moot, there's a standing problem, there's no case or controversy, whatever it is. They want to be clear that there's no procedural problem with the case before they formally grant cert. So what Chief Justice John Roberts does now, and it's kind of his thing, they will internally grant cert in a case, meaning they say, we're going to grant cert in this case, probably, and then they will relist the case for the next conference. And the conference is when the justices all come together behind closed doors, just the justices, and vote to hear a case or not. So usually the way this would work is they would come together, say, we're going to hear this case, vote to hear this case, and then it's relisted in a public setting, meaning it's relisted on the public list. And during the time period between the internal grant of cert, which is internal, not public yet, and the relist date, they look carefully to see if there's a procedural problem. If there is a procedural problem, they will then deny cert. And if there isn't a procedural problem, they will go through and then make their decision to grant cert public, and then the case will be granted cert, and the case will then be heard on the merits. Now, why is this extremely important to the Snope case, which is the most important case that we want heard, in my opinion, in the Second Amendment community? The two most important things that we need to have happen this year is Trump needs to win the White House, the Republicans need to win the U.S. Senate, and I guess the third related thing is that the Supreme Court grants cert in the Snope case, which used to be called the Bianchi case. The Snope-Bianchi case, of course, is the AR-15 ban, semi-automatic rifle ban case arising out of the state of Maryland, out of the U.S. Court of Appeals for the Fourth Circuit, out of Maryland and Virginia, right? That says that AR-15s can be banned and semi-automatic rifles can be banned consistent with the Second Amendment, which is just hooey. Supreme Court knows this is hooey, but we still need the court to take this. Now, the reason why this is significant is, and why the Gray versus Jennings case is particularly important, is remember I told you the Supreme Court only takes 70 total cases a year involving all aspects of American law? And they only take, 3, the most we can hope for is 3 Second Amendment gun-related cases. They've already arguably taken 2. The Vanderstock case involving framer receivers, the ghost gun case involving the ATF. They just took the Mexico versus the gun industry case, the Smith & Wesson case, where the government of Mexico sued American gun companies. And now that's up in front of involving the Pilka case, or the Plaka case, I should say. Okay. So now there's room probably for one more Second Amendment case. Well, we know that the Supreme Court has an interest in Snope. Why? Because if you recall from last week or so, Maryland asked for a second extension of time to respond to the petition for cert submitted by the Second Amendment parties in favor of the Second Amendment, asking the Supreme Court to grant cert in the Snope case. And Maryland asked for an extension. Now, here's where it gets geeky. Maryland asked for a 30-day extension of time. If the Supreme Court had granted the 30-day extension, which would have been the second 30-plus day extension that Maryland had sought, if the Supreme Court had granted it, then that almost certainly would have pushed the Snope case into the 2025-2026 term, if at all, if they're going to hear it. But the Supreme Court refused to do that. They specifically narrowed or shrunk the time that Maryland had asked for to respond and oppose the petition for cert in the Snope case. The consequence of that decision by Chief Justice John Roberts to shrink the time for Maryland to respond to the petition for cert in Snope meant that, and here's the key, meant that the Snope case will be conferenced by the U.S. Supreme Court, 9 justices for the first time in mid-December. If they decide to hear the Snope case in mid-December, it will be relisted into early January, and presumably what would happen is, after checking to make sure there's no issues with procedure, standing, mootness, anything like that, which I don't think there would be, the Supreme Court would then, upon the January relist conference, they would be able to grant cert and agree to hear the Snope case this term, 2024-2025. Now, the reason why I think this Gray versus Jennings timing is interesting is the Supreme Court took the Gray versus Jennings and gave them and demanded that Delaware respond, but then also gave them a sufficient amount of time to do so. But by doing what they just did, they basically have almost assured that the Gray versus Jennings Second Amendment case will not be heard in the 2024-2025 case. 25 term, I mean. So the question is, why did the Supreme Court specifically set dates in the Gray versus Jennings Second Amendment case involving preliminary injunction standards so that it's almost a certainty that the earliest that Gray versus Jennings case would be heard by the Supreme Court on the merits would likely be the 2025-2026 Supreme Court term? Why wouldn't the court want to rush Gray versus Jennings to the front of the line with a circuit split? And my thought is, it's quite possible that the Supreme Court has looked at their internal calendar at what they expect to be coming down the pike this term, 2024-2025, and they are aware that the Snope assault weapon, AR-15, AK-47, semi-automatic rifle ban is likely going to be on the docket, which is why they scheduled these briefings in the Gray versus Jennings Second Amendment case such that it's highly unlikely it would be heard this term. But in contrast, they shrunk the time for Maryland to submit their briefs to ensure that the Supreme Court would be able to conference the Snope's decision, or the Snope's case, in December and have it relisted and reheard, if you will, on the relist in the conference in January, in plenty of time to grant cert in January in the Snope case, hear argument, and decided by the end of June 2025. So while I have no idea exactly what's going on in the mindset or what's going on in the minds of the U.S. Supreme Court justices and the scheduling, I do find it somewhat significant as if you compare how they've just handled the Gray versus Jennings briefing schedule on this Second Amendment case, and then you compare it with how they handled the briefing schedule and essentially sped along the Snope case while in a sense slowed down the Gray case. Two Second Amendment cases arguably competing with each other for airtime or the opportunity to be heard this term by the U.S. Supreme Court. And by those indications, I would say those are favorable tea leaves to be reading in support of what we really want, which is the Supreme Court to grant cert in the Snope's case. Mission critical, we need a decision that says AR-15s, AK-47 semi-automatic rifles cannot be banned. They clearly cannot be banned if you apply Heller correctly, and I think the Supreme Court will 100% do so. If they grant cert in Snope, as I've said before, I think we have like a 99.5% chance that we're going to win this case on the merits. I mean, Justice Brett Kavanaugh, when he was a judge, already ruled in favor of AR-15s on the D.C. Court of Appeals. We know where Alito is. We know where Thomas is. We basically know where Gorsuch is, and there's no way that Chief Justice John Roberts is going to back down from the Heller precedent, even Chief Justice John Roberts. And I don't see any issues with Barrett on this either, because the law is crystal clear on the in common use test, and AR-15s semi-automatic rifles are undeniably in common use. But only time will tell. We will see. All right, folks, so there you have it. Hope you learned something here today. Hope it wasn't too geeky. Make sure you follow me on X at 4Boxes Diner, and make sure you like and subscribe to this video. Feel free to share this video with other people. We're trying to grow the channel as best we can, and look forward to talking to you very soon here at the 4Boxes Diner yet again.
Orders up. Table 2A.